What if the way you hire, pay, and manage your workforce is about to change fundamentally? India's labour framework is entering a new phase, one that will directly influence wage structures, employment relationships, and compliance strategies across organizations. Let's talk about a development that is set to reshape the way organizations manage their workforce in India. The implementation of the 4 new labour codes, viz. Code on Wages 2019, Industrial Relations Code 2020, Code on Social Security 2020, and Occupational Safety, Health and Working Conditions OSH Code 2020, which are notified on November 21, 2025. This reform represents a significant transition from the earlier 29 fragmented central labour laws to a unified, modern regulatory regime. For employers, this is not merely a compliance update. It is a structural shift in how wages, employment terms, social security, and workforce management are approached. While the codes have formally come into force, the regulatory architecture continues to evolve. On December 30, 2025, the government issued draft central rules for all 4 codes for public consultation, providing a 30-day window for feedback on the Industrial Relations Code 2020 and 45 days for the remaining codes. This consultation phase underscores the government's intent to refine implementation through stakeholder participation. So what does this mean in practice? At the core of the reforms is the universal application of wage provisions. Wage-related rules now apply to all employees, removing earlier wage ceilings and creating a uniform standard across blue and white-collar workforces. Alongside this, mandatory appointment letters formalize employment relationships and strengthen social security coverage. Another significant change is the formal recognition of fixed-term employment, FTE. FTE workers are now entitled to statutory benefits at par with permanent employees, including gratuity on a pro rata basis, reinforcing fairness and workforce flexibility. So why does this matter for your business? The uniform definition of wages has direct implications for CTC structures. Basic pay, dearness allowance, and retaining allowance must together account for at least 50% of total remuneration. This recalibration affects social security contributions and long-term employee benefits, prompting organizations to reassess existing salary models. The reforms also introduce tighter oversight across operations, restrictions on contract labour in core activities under the OSH code, higher thresholds for retrenchment and closure approvals, and mandatory grievance redressal committees reflect a stronger governance and worker protection framework. At the same time, enforcement itself is evolving. The inspector-cum-facilitator model prioritizes guidance and compliance support, while first-time offences may be compounded, encouraging corrective action over immediate penalties. Naturally, implementation calls for deliberate preparation. Organizations must revisit wage structures, update employment documentation and internal policies, reassess contractor arrangements, and strengthen grievance and compliance mechanisms. In a changing labour law landscape, preparation is no longer optional. Now is the time to review, restructure, and realign, so your organization is ready for the new regime. For businesses navigating this transition, informed guidance and a structured approach makes the difference. Stay informed, stay prepared. Rudal is here to guide you.